Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. The notoriety of the Baby M and Lisa Steinberg cases has resulted in changes in the adoption law, which offers greater protection to the adopted child. Today we'll look at the recent legislation in the area of adoption with our guests, the Honorable Renee Roth, Surrogate New York County, and Erin Britvan, co-chair of the Committee of the New York State Bar Association on Adoption. Hello, Judge Roth. Hello, Erin.
Alan.
Judge, can you share with us, tell us about the new legislation on adoption?
Well, it affects mainly private placement adoptions, and of course that's what the Steinberg case was about. We now have a pre-adoption certification so that a couple who wish to adopt will come into the court and seek to be approved if and when they do obtain a child. They're fingerprinted. We have a central registry to check whether there ever was a report about child abuse with the adoptive couple. But it isn't a perfect system, and if you're asking me, can a Steinberg case occur again, the answer is yes, because people like Steinberg consider that they're above the law, and no law that the legislature will ever pass can do away with someone like Steinberg. Do you agree?
I absolutely agree. What I've always said is you can punish immorality. You cannot legislate morality. And whatever the laws may be, it's like having, punishing crime, theft, murder, what have you. It doesn't stop people from doing these things. In this particular situation, we have laws which have been tightened up, but it's going to keep honest people honest, but there will always be Steinberg.
I think what it's probably done is made it more difficult for the honest people, the people who always came into the court with their adoption petitions.
Well, when you think of it, though, two laws came out of this, of essence. One is that papers for adoption, once you take custody, have to be filed within a particular time. Before the Steinberg case, there was no restriction on time. You filed it when you chose to file it, but of course people are always anxious to get it filed.
But it was always done quickly because
Absolutely.
People wanted the child to be theirs permanently, so they came in, they were there at 9 in the morning.
They wanted their papers filed so they can process the adoption.
Let me see if I understand this. Before the law changed, I could have a child in my home and yet not file the papers for months or years?
There was
That's
no
correct.
statutory requirement.
There's no requirement. There was no requirement. Now you are obligated or required under the law to file for adoption within a certain period. But we're not going to run out and find you if you aren't complying with the law.
Well, how did Steinberg get around the law?
Well,
what did he do?
You see, one of the questions that was asked when the Steinberg case received all the media attention was how did it fall between the cracks in the courthouse? There were no cracks in the courthouse. It never entered the courthouse. Papers were never filed. There was no way for the court to know that there was a placement there.
But you just told me papers were never filed, but there was no obligation for papers to be filed?
What happens is, as a practical matter, what the law always stated is that statutorily an adoption could not be finalized until at least 6 months from the filing of the petition.
Right.
As Judge Roth said, this would make everyone anxious, get the papers in quick so the 6 months can start running. But there was no mandate that you file at any particular time. People that were practicing an adoption law knew get it in very quickly. Someone that was less prone to know adoption law, a general practitioner who may not be familiar with it, might have held the papers for 30 days or what have you. In the Steinberg case, they were never filed. Certain papers were ostensibly, based upon what I read, were signed, but nothing was ever filed in court. So today the requirement is that if you take custody of a child, you must either apply for guardianship or petition temporary guardianship or petition for adoption within 10 days of taking custody.
Erin, you specialize in adoption. If there's a couple out there, and I always zero in on that couple with a question, if they want to adopt a child, now they're listening to the show and they're saying, let's do it. We can't have a child of our own. Let's do it. What do they do first? Where do they get started?
The first thing they should do is, obviously, there are a lot of support groups around where they can discuss with people who have gone through this before, where they can get recommendations, get ideas about international adoption, agency adoption, private adoption. The one thing I will tell these couples is that before they do anything, they should become aware of the fact that, as was just brought out, they have to be certified by the court before technically they can take custody of a baby. The amazing thing and procedures were that before the Steinberg case, and not that anything went wrong, but you took custody of a child, filed the papers in court, and sometime thereafter, and depending upon the court procedure, it could be a month later, it could be 2 months later, someone would be sent from the Department of Probation to visit the house, and this was all done after the placement. So the question might be...
Well, and the procedures are different in various counties, and also this pre-adoption certification does not apply to agency adoptions.
No.
It applies just to private
Private adoption.
Judge, that same couple or that individual who's considering adoption, I know we just told they have to be pre-certified. How do they know whether or not they're going to be approved by you? You give the approval, don't you?
The same way as they wouldn't know if I'd approve them when they come in with the baby, seeking to adopt the baby. A social worker has to investigate the home and see whether they're suitable parents.
Well, what if the
and a
person...
social worker does the same thing on a pre-adoption investigation than he or she would do once the child was in the home.
What I'm really asking...
And now there are two investigations, one pre and one after the child is in the home.
What makes a person or persons suitable parent or parents?
That's discretionary with the court.
Yes.
Share with us.
Okay. Again, the investigation is done by a social worker. What do I look for? I look for a loving couple who are seeking to have a child in their home to do for the child, not necessarily because it'll fulfill their yearnings and make their lives more complete.
Do they have to have the financial
And
ability?
they have to have some financial ability. They don't have to be wealthy, but they have to be able to support the child, unless we also have agency adoptions where the Department of Social Services
Do you
help.
take into consideration whether or not they have any children of their own?
Once it comes to me, I do not consider whether they have any children of my own.
Of their own.
Sorry. The child is in their home. All I have to determine is whether they will give this child a loving home.
What about on the pre-screening process?
That, again, that's not a concern of mine.
What about if
All I have to ascertain is whether they're suitable, appropriate parents.
Okay, what about a single parent?
Single parents may adopt in the state.
And what criteria do you, is it a higher standard for a single person to adopt than a couple?
As far as I look at it, no. I just want to make sure that the child is going to be well cared for. If the parent is going to work, then that the parent has made appropriate arrangements to care for the child during the day. Look, couples work and make arrangements to have their children taken care
Judge,
of.
in metropolitan New York area, we have a large homosexual population. What about a homosexual couple? Can they apply to adopt a child?
I haven't had one of those yet. You have to step back for a moment then and look at the adoption law. Adoption is provided for by statute and is strictly a creation of the law, not common law, but statutory law. It is purposed to provide a parent-child relationship, to give a child a home which he or she would not have otherwise. If this is a stable home, we would have to see what kind of agreement there is between the two people, and if the couple breaks up in the future, who has the obligation of support, visitation. These are all considerations that go into my concerns for the child. Where I have a marriage, then by law we have certain obligations. We would have them if there were an adoption. If both adopted, then both perhaps are equally responsible for the support of the child, but I'd have to consider it, as long as the child was a minor.
Okay. Aaron?
Well, it's amazing that, it is truly in the discretion of the court. And I have seen some things which I thought were rather puzzling. One recent surrogate, who recently retired, I should say,
Yes.
refused
Yes,
to approve a
pre-adoption
certification
yeah.
because the
Yeah.
adopting mother-to-be still used her name. And
No,
did not
it was
use...
a father. It was a
No,
no,
we're talking about a single person. That was a second case.
Oh,
I
you're
was
talking about the
sitting-
Westchester?
No, yes,
Yeah.
but I was sitting with him when they were being interviewed by the judge, and some judges choose to call them in for interview. And this particular judge very dignified individual, and he sat with
He
us.
looks like a judge.
Yes, well,
Not
so
like
do you.
me.
But he sat there for
No
a half
comment.
hour.
No comment from me.
He sat for a half hour, and this couple had a child already. Now they were contemplating another child, which was due in about 3 or 4 weeks. But they had to be certified. This was the last step in the process of certification. And he went over, and all of a sudden, recognizing, having read the home study before, that the adopting mother maintains her name and does not use the husband's name, he said he could not feel comfortable in approving the certification. His feeling was, projecting ahead, as artificial as it may be, is that as the child grew up, would probably be subject to ridicule by other children who will say there are 2 names in your household. The only thing that overcame that was my client saying that she loved her husband's name and that she was going to pick up on it. The same judge, by the way, I think this is what Judge was referring to, on the last day of his sitting, which I think was the 31st of December, there was an application for certification by a single man. And it's not, again, that he rejected it, but he said he would not give a carte blanche approval. He would want to see the situation develop where he had a particular baby to adopt before he would make a ruling. So he wanted to look at the entire picture.
Well, what is the fact that a baby is either white, black,
We're not talking about color.
No,
We're talking
no,
about
he
a single
wasn't
man.
talking about that, but this was a single parent, a man in this
I
case.
understand, but the fact of why does the type of child...
Oh, no,
bear
I guess
on-
he wasn't the type of child. I think what he was contemplating is that, assuming, and I don't know that it was a homosexual relationship or not a homosexual relationship, I think he wanted to be certain, and it might have been because of the attorney who was involved in the case, he wanted to be certain that the person placing the child had all the facts.
I see. Is there any hard rules, is there any legislation that somebody can read as far as what qualities make up for an adoptive parent, or is it just...
No, it's absolutely discretionary, and part of the things that are required is not only the home study, but it's also, as the judge indicated, there's a child abuse clearance check to make sure that you're not registered as a child abuser. There's a criminal record check. All these things are put together, and I think it really is a difficult task for a judge to make a determination, for the simple reason that the Lisa case became a media event, and we're putting the judiciary in a very precarious position. Sometimes they're afraid to make a determination because all they have is the papers in front of them.
Aaron, before you said to that couple out there, join the adoptive parent groups.
Right.
But what about, what else should they do if they wanted to actually take the next step?
Well, possibly, and I don't want to be, self-serving, see an attorney that may be involved in adoption, that may be able to advise them, because if they're going to be certified, in most cases they will be certified through the efforts of an attorney who might prepare a petition for certification.
Aaron, we have a very close friends of ours who actually advertised in out-of-state newspapers.
Right.
And they were very successful. They got a young girl who was pregnant and wanted to give up the child for adoption, and they got the baby that way. Have you found that as a viable...
I have found that advertising today accounts for about 80% of the successes I see. What I advise people to do is network. In other words, let people know that you're looking to adopt. When I was looking to adopt, I'm going back some 20-some-odd years ago, when I was looking to adopt, we felt it was a rather personal decision. We had no question that once we adopted a child, everyone can know about it. But in going forward for adoption, we told our relatives, our friends, we're contemplating it. So it was limited. Today I would tell you, or people out there, to tell everybody they're looking for adopt, because contrary to common belief, and I have to say this, I don't know even if the judge will recognize this, because I think we sometimes dispute this, we have these myths that exist, that there are very few children available to adopt. To adopt a child, one must wait unless they cut corners 4, 5, 6 years. That to adopt a child, you have to spend $15,000, $20,000, $30,000, $40,000, and they are myths. The premise is that because of abortion and because of the acceptance today of single parentage, there was a shortage of children.
Well, I've heard one thing, that
there are
adoptions
fewer
are down
children.
now. Have you found that to be
I
true?
have not found adoptions down. I'll tell you the problem that we're faced with. By telling people that adoptions are down, are pushing them to look how to cut corners. Their adoptions are not down because New York Times revealed, and other statistics revealed, teenage pregnancy is on the rise. 1.1 million teenage pregnancies annually in the United States. Another factor that came out recently in the New York Times was that the statistics on the number of people looking to adopt are not as great as has been reported. When people feel that there are too many people looking and too few children available, they're going to go down roads which may be cut.
But that doesn't change the fact that we had fewer private placement adoptions last year than we had the year before.
Well, it might
the
also
year
be
before.
because of the court, because two courts, I don't know how the family court has been doing.
No, they're the same. We average about 200 each a year.
Well, I'll tell you,
I think
I
part
can
of
get-
it
no, but I
is the
can-
fact that the South American countries
No, if I may,
are not
if I may
allowing
just
as
say
many
this,
children
there is
out.
another reason,
Yeah.
possibly. And there's an article, I'm not going to say what magazine because I'm not looking to lead anybody to the source. There are many lenient states out there that will entertain
Yes.
adoptions even by non-residents.
Yes.
And my position has always been if New York,
Pennsylvania, huh?
no, Texas. But if New York,
Just amongst us.
but if New York creates
4 million.
laws that are too stringent, it's going to drive people away from New York residents, and we're not going to afford them the protection they deserve. We're not there to tighten adoptions to the point of hurting people. We want to protect everyone. We want to protect the birth mother, we want to protect
Aaron-
the adopting couple, and the baby.
But that's
Aaron,
the
you-
problem with
before-
this kind of legislation.
Before you had mentioned cut corners, I want to explore that right after this break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
Every year, thousands of babies die from choking, suffocating, or other breathing emergencies. Just imagine how many of them could be saved if only they came with instructions. Please learn American Red Cross Infant and Child CPR. American Red Cross. We help you help others.
I was going to take a job with an engineering firm in New York. I got a better offer. I'm building schools overseas with the Peace Corps. The pace is a little slower than New York, but here I'm getting grassroots experience I couldn't get anywhere else. The way I look at it, the world can wait 2 years for another 40-story smoked glass high-rise.
Peace Corps, the toughest job you'll ever love.
I don't know if you'll remember me, but I'll never forget you. I'm Mr. Signorelli's daughter. I didn't think about what would happen if he went into cardiac arrest. I didn't realize that at 6 a.m., a nurse would call the shots and save his life.
If you have the smarts and the guts to study biology, chemistry, anatomy, and psychology, call 1-800-962-NURSE. If caring were enough, anyone could be a nurse.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today's topic is adoption. Our guests are Judge Renee Roth, surrogate in New York County, and Aaron Britvin. Aaron specializes in adoption law. Aaron, before the break, you had mentioned something about cutting corners. What does that mean in adoption?
You have to understand that people who are looking to adopt have already gone through a lot of anxiety and frustration in their desire to have children biologically. When they pass over the threshold and look to adopt, they're going to go down a new road. Sometimes the road appears bumpy. Sometimes they look at their past frustrations and they view this as additional frustrations. Under the laws of the state of New York, and many states, only agencies are licensed to place children. Attorneys are not licensed to place children. But unfortunately, there are attorneys out there that will, and the individuals that are not attorneys likewise, who will say they maintain lists and will say, look, when you do advertising, that's an appropriate way. There's no intermediary, there's no middleman. A person is going looking for a situation. When you're going to an attorney that says, I will find you a baby, or advertise for 3 or 4 weeks and then come to me, you can know a lot of things. Number one, that you're going to be paying a lot of money, and two, that there's a violation of the law. And I will say this, that there is no reason to violate the law. There's no justification for spending huge sums of money, and there's no reason for going to anyone where you're going to cut a corner.
You have to remember that there are two routes to follow with adoption. There are private placement adoptions and there are agency adoptions. And the difficulty for us sometimes occurs with the private placement adoptions. New York is one of the few states left in this country which allows private placement adoption.
I must dispute it. There are only 5 states that don't allow private adoption.
I
All
think
other
it's the
states.
other way around.
No. I'll name them. You're wrong. Delaware.
Okay, right.
One second, Aaron. Judge, let me ask you this. In a private placement adoption, what are you allowed to pay for?
Just your legal fees, the normal, reasonable legal fees. Some expenses for the birth mother,
Can I pay her
hospital
her
expenses,
obstetrician?
perhaps all of those expenses. Also, I think if she couldn't work the last couple of months, anything
Let's go-
within reason.
you
Are
see-
these expenses reviewed by the court?
Always,
has to
and
be
you
set
have
forth.
to set them all forth.
Aaron, if I may, I just want to get on to a different topic. Your baby S case. Can you tell us about that, please, Judge?
Yes, in 10 minutes?
Or less.
Which is or less. This concerned the rights of an unwed father. There were 2 lawyers who were the adoptive parents in this case. The birth mother had decided to give up her child for adoption, contacted a lawyer who put her in touch with these 2 attorneys, and the birth mother did not tell the natural father that she was surrendering the child, in fact denied her pregnancy to him. He at some point, he wanted to marry her, he at some point found out that she was in fact pregnant. He brought a proceeding in the family court for custody of the child before the child was born, while the woman was still pregnant. And she never, they didn't answer the calendar. That was in Suffolk County. The people didn't answer the calendar. And the poor father, whose name was Gustavo, just never was given the runaround. The adoptive parents brought a petition for adoption in the surrogate's court.
These are the
New
2
York
lawyers?
County. The 2 lawyers, Jane and Ed, were their names. They brought a petition for adoption because after the baby was born, the little girl was given to them, and they never disclosed to me that there was pending in Suffolk County a proceeding by this man to obtain custody and declare his paternity of the child. And I had to decide whether, in fact, the statute gave Gustavo the right to object to
This is the
the
new
adoption.
legislation.
No, we're talking about the old
Okay.
but when I tried this 2 years ago in 1988, I was operating under the old statute. That statute has now been declared unconstitutional because of this case. The statute gave, and still gives until the legislature changes it, and I assume will always give to some degree, unwed fathers less rights than unwed mothers to their children. And for an unwed father to contest the adoption of his child, he had to qualify or meet the requirements of the statute. He had to have lived with the mother or the child for 6 months next preceding the commencement of the adoption proceeding. He had to have held himself out as the father, and he had to have provided medical support when the woman was in the hospital, or financial support for her. Well, in our case, he met the last 2 requirements because by bringing these proceedings, he held himself out to be the father, and he also obligated himself to support the child. Question was, what about the fact that he didn't live with the mother or the child? He couldn't have lived with the child for 6 months because the child was surrendered at birth. He couldn't live with the mother because she didn't want him there. And so you were giving him the right to contest the adoption of his child if he met 3 criteria, one of which was outside his control. That wasn't constitutional.
And the appellate
And I
courts?
said agreed all the way up. The Court
Aaron,
of
what do you think of that?
Appeals has just declared
Well,
it
the problem that we
unconstitutional.
have here is the fact that one of the elements, the living together, the judge said was held to be the item that was unconstitutional. There is another statute which deals with when you have to give a birth father notice. It's 111A, which says that in certain situations where the birth father is known but doesn't fall under the requirement of needing his consent, you still have to give him notice, and he can come forward in court, may not maybe not to get custody, but at least to discuss the best interest of the child. What we're faced with now is the reality that the legislature has to act to amend the statute so it falls within the Constitution and to try and set some criteria that will be deemed a constitutional measurement of when a birth father's rights are necessary, because otherwise there's going to be a lot of children potentially in limbo.
Judge, another topic, the Baby M matter. What's the status now in New York State regarding surrogate parenting?
There was some attempt to develop some legislation about surrogate parenting, but I think the public doesn't have any firm idea where it wants to go, and the legislature isn't going to do anything.
What happened is we had with the Baby M case, like the Lisa Steinberg case, unfortunately, it was a media event. And when it was in the headlines, the legislature came out with 3 or 4 different proposals, none of which were agreed to. With the Baby M case having subsided, those potential bills are lying there, and it is no law.
Well, I understand, but what is this?
I don't think there is very much activity in the area again.
Well, not in New York State,
not
obviously.
in New York, yeah, and I don't know
See,
why.
one of the criteria in New York State...
Again, that imaginary couple who's out there who wants to go this route of surrogate parenting.
Oh, I would recommend against it. I would definitely recommend against it for the simple reason that there is no law on the subject. You cannot have a binding contract in advance in saying what will be. You have usually coupled with the element of surrogacy the payment to the mother carrying the child, $10,000, which New York frowns upon, because you cannot pay someone to give a child or to bear a child. And that was in the Baby M case where the carrying mother said she wouldn't take the money.
Judge, what's your opinion on surrogate parenting?
I don't have an opinion on it. It's a question that might come before me, and I could never
Well, I can say something
it.
else, and this is not because of any reason not because I'm trying to push adoption. I think the main reason why people go surrogacy is because they are looking, I'm not faulting it, but they're looking for genetic identification. They do not recognize that a child that comes to you by any means is going to be loved like it was your own. I've experienced it. I know it. But like even in the Baby M case, the Stearns, he had indicated that his family had been wiped out in the Holocaust. There was no one to carry on the name, and he needed this genetic identification. I think when you have surrogacy, it's because of that need. Let me tell you something. To be a parent, no matter how it comes to you, the love is just the same when you take care of a child.
Judge, in the minute we have left, what's your advice to the couple who wants to adopt?
Oh, I think the advice should come from Aaron rather than from me. My only advice is to do it the right way and to know that you have a number of different avenues available to you and that we're there in the court to help you and not to hinder you in any way. And many people, I see it during my adoption calendar, and they come in and they're trembling, thinking that I'm going to in some way take the child away. It's the last thing in the world that I'd ever want to do. I'm delighted that people want to take children into their homes and give them love and affection.
Surrogate Roth, thank you very much for appearing.
It's always a pleasure to be here. I enjoy it.
Thank you, Aaron Britvan. Thank you very much for appearing on Lawline. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney, author and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Lawline, 27th floor, 63 Wall Street, New York, New York, 10005.